Well, welcome to BritCourt's first online public law team. In fact, I think our first online team seminar at all. Thank you for joining us. Please allow me to apologise in advance if any dogs bark or front doorbells ring or small photobomb the proceedings. I'm sorry Lord Anderson QC couldn't be here to chair this meeting. As many of you will know, his father sadly passed away very recently, and I'm sure you'd all wish to join us in expressing our sadness and our condolences to David and his family. We have 6 presentations this afternoon. They're all timed at about 7 minutes, and we only have an hour to get through them, so I'm going to keep the introductions to a minimum. If anybody does have any questions arising during the course of the seminar, would you please email them to me at my BritCourt address. It's paul.bowen@britcourt.co.uk, and I will do my best to ask them on your behalf of the speakers at the end of the talk. Our first speaker is Malcolm Birdling. Malcolm is, among other things, the Secretary of the Constitutional and Administrative Law Bar Association and on the Attorney General's B panel of counsel, the EHRC's panel of counsel, and he's going to be speaking today about the amenability of private bodies to judicial review. So take it away, please, Malcolm. Thank you.
Thank you. You can all see me and, more importantly, hear me. In the abstract, a question like, can you judicially review KPMG would sound like it has an easy answer. Obviously not. What planet are you on? And that was more or less the response that the defendant gave in their summary grounds of resistance to the decision which I'm going to be speaking about this afternoon, Holmcroft Properties and KPMG. The context is that for a number of years, the biggest UK banks were behaving badly and missold what are called interest rate hedging products to small businesses. Now, you don't need to know what an interest rate hedging product is to follow the story, but in short, they were products which small businesses they were sold to didn't need, couldn't understand, and couldn't afford. The Financial Conduct Authority investigated and concluded that this was a widespread problem. The authority has a range of statutory powers which it could have used to put the situation right. And they made it clear that they were planning on doing so. So the banks, realising that their banks were against the wall, proposed a deal to the FCA. They set up their own redress schemes, so the FCA didn't have to use any of its statutory powers, and they would investigate all sales of IRHPs to businesses who met certain criteria, found out where these were missold, and then make those businesses good. The FCA wasn't happy about the banks being judges in their own court, and they didn't have the resources to oversee the processes themselves. So someone came up with a cunning plan. The FCA would use another of its statutory powers, usually used for investigations, by which it could appoint, or actually more specifically, it could require the banks to appoint what's called a skilled person to report to the FCA about the regulated firm's business. The banks agreed with the FCA that a skilled person would be called an independent reviewer and would be tasked with independently overseeing the redress exercise, reporting regularly to the FCA, and crucially, ensuring that what was called appropriate, fair, and reasonable compensation was paid. In other words, the independent reviewers were doing what the FCA would have done if they had the resources to do so. The review process then got underway, and there were, as is inevitable, businesses who felt aggrieved and considered they should have been compensated more. So that was the position that my lay client found themselves in. The bank, in this case Barclays, had agreed with the FCA that KPMG would act as independent reviewer. Barclays had concluded that my client had been missold IRHPs and was due compensation, and KPMG agreed. So far, so good. However, the bank concluded this should be only basic redress and not damages for consequential losses. The reasons were set out in a provisional decision letter, which set out broadly the basis for the conclusions. But the letter seemed to rely on in reaching those conclusions on the bank's internal documents and records, which Holmcroft just didn't have and didn't know what they said. So Holmcroft, by their solicitors, wrote back disagreeing with the decision and saying, well, we'd like to be able to tell you why it's wrong, but we can't without these documents, so please give them to us. The bank disagreed, refused to disclose the documents, and then confirmed the preliminary decision. KPMG, in fulfillment of its duties to the FCA, approved that decision as appropriate, fair and reasonable. So that sets the scene for the judicial review. The grounds of challenge what you might call vanilla public law ones. KPMG had acted in a procedurally unfair manner. But before we even get to that, there's a very large roadblock. Is KPMG even amenable to judicial review when performing this function? The starting point is that judicial review is available in respect of the exercise of public functions, even when they're being exercised by a private person. So Holmcroft contended that the public function which was being exercised by KPMG as independent reviewer was what the FCA had required it to do. That is, approving and agreeing that the redress proposed for each customer was appropriate, fair and reasonable. The FCA had required KPMG to be appointed pursuant to a statutory power, and they were effectively, KPMG that is, acting as the FCA's proxy. KPMG said, no, when we're making this assessment, we're exercising contractual rights, and we're discharging contractual obligations, emphasising that the scheme was a voluntary one. Now that's important because it's well settled that when a decision is a purely private matter governed exclusively by contract, with no public law character, it's not amenable to judicial review. And the classic case there is of a private arbitration where everybody's agreed that it's going to be dealt with privately. Short of those clear cases, the law is, to use a technical term, muddy. The test is that set out by Lord Dyson in a case called Bear, which concerned whether a private company operating a farmer's market was amenable to judicial review. And the test Lord Dyson set out was, does the decision have a sufficient public law element, flavour or character to bring up with the purview of public law? As you can see, it's not exactly a bright line test. So this was the test that the Divisional Court at first instance had to apply. Lord Justice Elias said that he ultimately hadn't found the easy question to resolve in Holmcroft's case, but that he'd ultimately concluded, not without some hesitation, that the independent reviewer's duty did not have sufficient public law flavour to render it amenable to judicial review. There was then an appeal, and the Court of Appeal agreed, although unfortunately it's not clear why. And to reassure you that this just isn't just sour grapes, in an article published in this month's issue of Public Law, Professor Kevin Costello agrees, and he identifies three possible explanations for the Court of Appeal's decision. The first is that the courts concluded that the independent reviewer couldn't be classified as a public body. It doesn't seem that that could be the reason, because the Court of Appeal agreed that KPMG was for this purpose acting on behalf of the FCA. The second is that the independent reviewer was acting in a private manner since it was performing a function within the public domain, of the private domain that is, no different to that performed by a private actor. It doesn't seem that that was the reason either. The independent reviewer was a component of a wider scheme that the Court of Appeal accepted was regulatory, and regulation is not something that private actors undertake. And the third is that some other concern affected their characterisation, and this I think is the reason, and Professor Costello agrees. The Court of Appeal placed heavy emphasis on the fact that the decision merely affected Holmcroft's private rights. The compensation scheme generated private law rights against Barclays. The independent reviewer's oversight was ancillary to pursuit of those claims, and that coloured the entire transaction. If that analysis is right, then as Professor Costello argues, and I agree, Holmcroft appears to suggest that a decision by a public administrative body, which has been instituted for the purpose of regulating or adjudicating disputes, will not be amenable to judicial review, where those underlying claims can be characterised as private law claims. If that's so, then Holmcroft may have quite significantly reduced access to judicial review. For example, why would the same principle not apply to the case of Mr. Bear, who had his application to lease a stall in a farmer's market rejected? It was said by the council that the right to lease a stall was a private law right, and the refusal was no different to a decision which might be made by a private law landowner and give rise to a private law right. But the Court of Appeal said that that was amenable to a review. So I've got to bring it to a close now, and the ultimate conclusion is, before Holmcroft I said the state of the law was muddy, and after Holmcroft, depending on how you look at it, the law is either muddier or there's two piles of mud that you can choose from. Thank you.
And I'm going to ask Emily to go next. I said this was the first time we'd done this. I'm sure we've all got a few teething problems. Emily's going to talk about Cochrane and the Cabinet Office, which concerns the divisive topic of voter identification. And she's going to be talking about Padfield's challenges, that's to say claims the power has been used for a purpose that is not authorised by the statute. Thank you very much, Emily.
Thanks very much, Paul. Hopefully I can be heard. So, as Paul said, the background to the case I'm going to discuss is the somewhat politically controversial topic of requiring voters to produce some form of ID when they turn up to the polling station in order to be able to vote. Though, as is so often the case with judicial review, the case didn't actually concern the merits of that interesting policy at all. Rather, it was about the decision of the Cabinet Office to run various so-called pilot schemes in last year's local government elections, which trialled various forms of ID. And so the idea behind the pilot scheme system is that if the government wants to have a go at some new arrangement when it comes to voting, they can pass temporary changes to the relevant delegated legislation for a particular local authority for a particular election. They can see what happens, and if the pilot's a success, they can roll it out on a national basis under another power. So there were two grounds of challenge to these particular pilot schemes. The first was a pretty traditional statutory construction ground, and unfortunately I don't have time to deal with that today. And the second was what's known as a Padfield purposes challenge, and that's what I'm going to focus on. Now, it's a well-known principle of public law that a public authority can only exercise a statutory power in accordance with the policy and objects of the statute. And a claim that a power has been exercised outside those lawful purposes is often referred to as a Padfield challenge, after the Padfield case, which established the rule. It was common ground in this case that the background to the decision to run these pilot schemes was a growing concern that the UK electoral system is vulnerable to fraud. And there had been various official recommendations that types of voter identification be trialled. Now, the power to run pilot schemes is contained in Section 10 of the Representation of the People Act 2000. And the claimant argued that the policy and object of that statute is to facilitate and encourage voting. So in other words, he said it's all about turnout at elections. And he claimed these pilots would inevitably have the effect of decreasing turnout because they would lead to legitimate voters being turned away from the polls because they didn't have the right ID. So he said they frustrated the legislative purpose and they were unlawful for that reason. Now, my client, the Cabinet Office, we argued that the permissible purposes were wider than that, and we said they were intended to allow proposed changes to local government elections to be tested with a view to modernising those procedures in the public interest on an informed basis. But we also said in the alternative that even if the aim was as narrow as the claimant suggested, these pilot schemes fell within it because they would in fact encourage turnout in the long term because they would increase public confidence in the system. So in terms of who was right, the key question, of course, is how do you identify the policy and objects of a statute? And that's a pretty important public law question, and it's somewhat surprising, perhaps, that there's relatively little authority on it. And I think that might be quite important because we may well see more of these Padfield-style challenges in light of some of the very wide powers that have been granted in the Brexit legislation and the COVID legislation, for example. So in terms of the case law to date, it's certainly clear that the guiding light is the words Parliament has chosen to use, and that the whole thing is an exercise of construction. But of course, that can be very difficult to apply. So, for example, in my case, the claimant emphasised a particular provision in Section 10, which required the Electoral Commission to produce a report on the pilot and to judge its success or otherwise in facilitating or encouraging voting at elections. And the claimant said, aha, that reveals the purpose behind this power. But we were able to point to other facets of the wording. For example, the Cabinet Office can require the Electoral Commission to report on all sorts of other matters. The power can also be used for pilots which really have nothing to do with facilitating voting because, for example, they're about counting of votes. And we also argue that the nature of the power in itself is telling, because for one thing, it's a power to experiment. So we said it would be surprising if that was intended to be narrowly construed. And for another, it was a permanent power given on an ongoing basis. So we said it would make more sense if it was conferred to deal with problems as they arose in the future, rather than a specific problem that confronted Parliament when the power was enacted. And then what about extrinsic material? So it's tolerably clear that it is legitimate to look outside the four corners of the statute in identifying policy and objects, but we said that that was subject to some important qualifications. So first we argued it's not legitimate to look at Hansard material when you're dealing with a Padfield challenge, and that was particularly because in the case of Sparth Home, the dicta there made that particularly clear, we said. And in terms of other material in this case, there were various parliamentary reports that had led to the recommendations in the bill. We said, well, the court needs to be very careful when it examines this material, because it can't override the words Parliament has used. And you have to be careful in distinguishing the mischief Parliament was addressing with the effect of the legislation has actually passed. So what happened when all this came before the courts? Well, Mr. Justice Supperstone at first instance agreed with us and found the pilots to be lawful. He identified the permissible purposes quite broadly, but he didn't really grapple in detail with this question of principle: how do you identify the policy and objects? And his conclusion seemed to rest on a combination of analysing the language and the background reports. The claimants appealed to the Court of Appeal on both questions, and the Court of Appeal heard that appeal via Skype yesterday. It would of course be foolish of me to give any kind of indication as to which way I think it'll go, but I think it's safe to say they're likely to address head-on all the sorts of questions I've been raising here. So I think this case is likely to be an important precedent when it comes to future Padfield challenges, and as I said, I expect we might see rather more of those. Thank you.
It's well known that there's been a recent steep decline in rape prosecutions brought by the CPS. And Jenny's going to talk about her experience as junior counsel with Emma Mockford in a case brought by the End Violence Against Women Coalition, challenging the actions of the CPS on this issue. Jenny.
Thank you very much, Paul. As one of my colleagues, and doubtless to the disappointment of our market, I'm going to discuss a case that I lost. Try and be fair and balanced presenting it, but I will almost do so. However, in an awareness, I'm going to start with the factual background, and in particular the common ground between the parties. First, as Paul has said, it's now common knowledge that since 2017 there has been a collapse in the volume and rate of charging decisions in rape and sexual assault cases by the CPS. That precipitous fall has been the subject of much public and indeed governmental concern. Second, it was also common ground that in precisely the same period there have been changes to the guidance provided to prosecutors. In particular, binding legal policy documents which to apply what is known as the merits-based approach were removed. Secondly, prosecutors attended training sessions in which they were encouraged not to apply that approach. And thirdly, a new target for rape prosecutions was introduced. Finally, it was common ground that these actions by the CPS took place without ever being communicated to the public, without any consultation, without any consideration of the public sector equality duty, or any of the other typical procedural protections that would apply to a change of policy. In the circumstances, the End Violence Against Women Coalition, represented by the Centre for Women's Justice, sought to challenge the CPS's actions. In particular, we, and I was led by Paul Bowen QC, argued that there had been a change of approach. Whether that change of approach was characterised as a change of policy, a change of practice, or both, the claim was truly mammoth. It was supplemented with detailed evidence, including anonymous whistleblowing evidence, statistical analysis, case studies, and evidence from advocates in the women's sector. The CPS also put forward a detailed defence to the claim. At its heart, however, was a very simple contention. There had been no change of approach, it said. That was, to put it mildly, a little surprising. As I have said, it was common ground that there has been wholesale removal of binding legal guidance, and it was also common ground that there had been a contemporaneous drop in rape and sexual assault prosecutions. Moreover, internal contemporaneous documents describe the actions of the CPS as a touch on the tiller or a marginal change in the policy adopted. Indeed, the CPS, the Director of the Legal Services, recorded that, and I quote, "A number of dedicated members of staff who are highly committed to this work could be highly concerned by what could be described as a change of approach to prosecuting cases of this nature." However, the CPS's argument, although it never quite put it this way, was that despite those changes, there hadn't been a change of substance. As such, there had been no judicially reviewable decision at all. It therefore wasn't required on its analysis to follow any of the procedural requirements around policy changes. Faced with those two different arguments, the Divisional Court indicated that this claim was unusual, if not unique. Now, that is something you never want to hear when you're bringing a judicial review. But the reason for it, according to the Divisional Court, was that the legal grounds of challenge are not the primary subject of dispute between the parties. The key question was actually whether there had been a change of approach and therefore a judicially reviewable act at all. The Divisional Court found, in agreement with the CPS, that there had not been a change of approach. Exactly why it found that is not wholly clear from the extempore judgment that was given, in fairness to the court, in haste the same day. There are a range of factors referred to and references made both to this being an issue of law and one of fact. Evil has put in a comprehensive appeal against the judgment of the court. But I want to focus in particular on one element of that judgment, which is the court's reliance on the fundamental principle that in judicial review, the courts will proceed on the basis of the evidence presented by the defendant. In this case, that the court was required to follow the position of the CPS that there had been no change of approach. With the greatest of respect, very distinguished Divisional Court that heard this case, and this is where my attempt at neutrality does fall away, that approach seems to me to be fundamentally flawed. It is, of course, correct as a matter of constitutional principle that the courts defer to decision makers on questions of fact within the decision maker's expertise. But in my view, that important constitutional principle cannot extend to the type of question in issue here. First, in light of the common ground that I've already referred to, the dispute wasn't, in fact, a dispute of fact. While there were narrow areas of factual dispute, the real question was how to characterise as a matter of law matters which were broadly common ground. In those circumstances, I would submit deference to the decision maker is not appropriate. Second, even if it were a question of fact, in my respectful view, it's not appropriate to defer to the decision maker on the threshold question of whether or not there has been a judicially reviewable decision at all. That would risk granting decision makers the ability to determine, delineate the jurisdiction of the court, which cannot be right as a matter of principle. Third, extending the principle of deferring to decision makers in this way risks neutering the ability of courts to consider questions that, in my opinion, should properly fall within its purview. As a matter of policy as well as principle, it is gravely disappointing that victims of rape have been denied the opportunity to ventilate the question of the legality of the CPS's policy in a judicial forum. That disappointment was tangible from the numerous victims present in the courtroom when judgment was delivered. Evil has appealed. It is my sincere hope that the court will grant permission to appeal and that we will get a more detailed consideration, and possibly a different outcome on this issue, but we will have to see.
Thank you, Jenny. Now, we haven't been able to so we're going to move on. David's going to talk about developments in relation to government surveillance regimes and rights under the European Convention and EU law to privacy, freedom of expression and protection of personal data.
Thanks very much, Paul. As is mentioned in the blurb on our website, I've appeared in 3 recent cases on this topic. The first is Liberty's challenge to the Investigatory Powers Act in the High Court. That Act is the UK's new flagship surveillance regime, which provides in particular for retention of communications data and also for bulk interception, bulk equipment interference or hacking, retention of communications data in bulk, and the retention and use of bulk personal data sets. Bulk powers are essentially those that allow very large amounts of data not likely to be of intelligence interest to be retained, stored, and analysed. The second case is the Grand Chamber hearing before the European Court of Human Rights in the 10 NGOs and Big Brother Watch decision, which is the challenge under the ECHR to the previous UK bulk interception regime in the Regulation of Investigatory Powers Act. The third case is in claiming the Investigatory Powers Tribunal that Liberty brought, and Privacy International brought in January of this year, in light of disclosure that was received in the High Court challenge. That disclosure was broadly to the effect that MI5's retention, review and deletion processes in relation to one technology environment were ineffective, leading to what it called ungoverned spaces in a letter to the Investigatory Powers Commissioner. The claim seeks, amongst other things, the quashing of all warrants issued to MI5 on the incorrect basis that it had compliant retention, review and destruction or RRD systems, and relief in relation to the potentially unlawful retention of data. The aim of this presentation is to give a very brief overview of how the law in this area might develop, possibly in the near future, given some pending decisions. In general, there are two main constraints on mass surveillance regimes. Firstly, under the ECHR, unusually, these regimes can be challenged in the abstract because the purpose of secret surveillance will be defeated if the target knows of it, at least at the time. The European Court, therefore, allows an abstract challenge to the legal framework, in which it asks whether there are sufficient constraints on the power. And it looks in particular at the purposes for which it might be exercised, duration, the rigour of authorisation procedures, safeguards for examination, use and storage, and requirements for destruction to see whether that regime is sufficient. In effect, it looks to see whether the domestic regime itself ensures that each surveillance instance will be proportionate in convention terms. The second main constraint is that arising under EU law and what's become known as the Watson requirements. Any national law regime for general retention of communications data must arguably meet 5 requirements. First of all, purposes of retention and access must be limited to sufficiently weighty reasons. The system cannot permit general and indiscriminate retention. There must be prior independent authorization of access to retained data. There must be notification of the target after their data is accessed, once that won't jeopardize the operational purpose of access. And it seems also that data must be retained in the EU. How might these requirements develop and how are they relevant in the UK? Well, first of all, as to the Watson requirements, the IPT in September 2017 referred questions to the CJU, including whether it really meant what it seemed to say in Watson, and secondly, whether these requirements apply in the national security context, so to MI5, MI6s and GCHQ's retention of and access to bulk data. The reference has been heard and there's no decision as yet. However, there are Advocate General's opinions in this and related cases. And those opinions are to the effect that the Watson requirements should indeed be reaffirmed, albeit with slightly more flexibility for member states, and also that they do indeed apply in the national security context. Liberty in the Divisional Court challenged parts 3 and 4 of the IPA, which is the new communications data retention and access regime. Communications data, by the way, is everything but the actual content. So, for example, who, where, when of a communication. By February 2018, it was conceded that that regime was incompatible with EU law, insofar as retention and access for crime was not limited to serious crime, and there was no independent prior approval of access. If the CJU were to accept the Advocate General's view, then it seems to follow that the amendments to the IPA, in light of the Divisional Court's decision, do not go far enough because they don't apply retention and access for national security. It seems likely that Part 6, the bulk communications data retention power in Part 6 and Chapter 2, and perhaps other powers could be challenged on this basis. As to the ECHR requirements, in Big Brother Watch, which was the ECHR challenge to RIPA, the previous bulk interception regime, the IPT held that that regime complied with Article 8. The Chamber in the ECHR held that there were violations of Articles 8 and 10, including a lack of oversight of the process of examining intercepted material, which the government calls selection for examination, and further, an absence of safeguards in relation to the use of communications data that was intercepted with content. The case was referred to the Grand Chamber, and I was lucky enough to be arguing that for the applicants in July 2019. We made two arguments. First of all, that the Grand Chamber should strengthen the safeguards that are required, and more fundamentally, the bulk surveillance is generally not compatible with the Convention. There is again no judgment as yet. There were certainly some interesting questions from the court, including quite a direct question to the government as to why the CJEU's case law should not guide the European Court of Human Rights in relation to the requirement of prior independent authorization. How are these requirements relevant domestically? Well, Liberty also challenges the IPA bulk powers on ECHR grounds, and that challenge was heard by the Divisional Court in June 2019. For that purpose, the parties treated Big Brother Watch Chamber decision as representing the law, and accordingly the court held that the powers challenged were not inherently too wide. In addition, we said that the various defects that were identified in Big Brother Watch also applied to the IPA, but again, that was rejected by the Divisional Court. Time for appeal in that case has been extended until after the Grand Chamber decision is delivered, and so what ultimately happens there is very likely to depend on what the Strasbourg Court says. Finally, the MI5 case, very briefly, as mentioned, that claim is brought to challenge particular conduct and is therefore in the IPT. Challenge warrants on the basis that they were issued on a fundamentally incorrect factual basis, and also that data may well have been unlawfully withheld or retained, rather. That will be heard in February 2020, so watch this space.
That's great. That's great. Fascinating issues. And I hope we have time on those towards the end. We've now, I think, managed to find Tim in the ether. So Tim is now going to talk to you about the cases he's been doing on Article 1, Protocol 1 and legitimate expectations. Thanks, Tim.
Thanks very much, Paul. So I'm going to be talking about a case between British Telecom and the Treasury, in which I appeared for the Treasury that was heard in the Divisional Court and then the Court of Appeal last year. The case arose out of the introduction of the new state pension in 2016. And one of the consequences of the introduction of the new state pension was that one tranche or slice of historic pension entitlements was no longer going to be indexed, because the new state pension and its introduction had effectively turned off the mechanism for that indexation. Now that created a problem for the government, because express undertakings had been given to public service pensioners that that tranche of their pension would always be subject to indexation. And so the government consulted on what it should do. And the core questions were, firstly, should we use the ordinary mechanism that we have available to us for turning back on the indexation of that tranche of pension entitlement? And secondly, if we do, what consequences is that going to have for private sector pension schemes? And the reason I asked that question was because there are a number of private sector pension schemes that have mirroring provisions. So they say, in effect, if public sector pensioners get benefit X, then you in our private sector pension scheme will get the same. And the reason for that, to take the example of BT, who brought the particular judicial review claim, was that there are BT employees who were originally public sector employees prior to privatisation in the 1980s. So the Treasury consulted, and BT responded and came up with an elaborate and they thought ingenious strategy whereby the Treasury should index that tranche of public sector pensions, but should use a novel route. that had never been deployed before as a means of preventing triggering the same liability in their own pension scheme. And if they did, they said this would save BT up to around £600 million. The Treasury decided not to go down that route. They used the ordinary mechanism and BT issued proceedings. And the case was heard in the Divisional Court before, as it was then, Lord Justice Hamblin and Mrs. Justice Whipple. And one of the key issues at the heart of the case was a very complicated, rather esoteric question about vires in the pension sector, which I think it's fair to say is not of general application. And I don't propose to talk about that particularly today, but I do want to talk about 3 points that arose out of that case that it strikes me do have some general interest and some general application within the context of a judicial review. And the first of those concerns substantive legitimate expectation, because the Divisional Court found that BT's pensioners enjoyed a substantive legitimate expectation that the government would continue to index public sector pensions in the way they always had done, and that legitimate expectation amounted to a property right for the purposes of A1P1. That strikes me as a very interesting finding, because there was no express undertaking given to the BT pensioners, which is not novel of itself. Of course, a legitimate expectation can arise out of the course of conduct. But what was striking to me about this case was that the course of conduct concerned a different group of people. So the course of conduct related to the indexation of public sector pension and public sector pension entitlements. But nonetheless, the court held that that gave rise to a legitimate expectation for the BT pensioners as to what would be done in respect of somebody else's pension altogether. And in my view, that's one of the most expansive findings in this jurisdiction, at least, in relation to A1P1. It follows, I think, from other cases you're probably familiar with, like the PCSU case about civil service benefits. And I think this is a whole line of case law that we need to watch quite carefully. Secondly, and more quickly, the case went to the Court of Appeal, and BT very squarely and very fairly accepted that their appeal challenged findings of fact at first instance. But what they argued was that this was a judicial review, there had been no live witnesses at first instance, the judges at first instance had no better means or mode of assessing that evidence as the Court of Appeal did, and therefore, of course, there must be deference to the judges at first instance, but it's in a category that would be rather different to, for example, a trial where there had been live evidence. The Court of Appeal disagreed, and in fact, the Court of Appeal said that the standard on an appeal on the facts on a judicial review claim is effectively the same as where there has been a substantive trial with live witnesses. And that was an interesting finding, in part because it wasn't even being urged on them by the Treasury. We were saying that there's a sliding scale on this question, and we recognised that there needed to be some modulation of the test. The court disagreed, and I think that's going to be an important conclusion, an important finding for future judicial review appeals to the Court of Appeal. Finally, the third point I wanted to raise related to Section 31(2)A of the Senior Courts Act. This was one of the rare cases where the court found that even if a remedy should be granted, the error, the public law error, would have made no difference, and therefore the remedy would be refused. The factual backdrop was complicated and fraught, let me put it that way. In short, the Chancellor of the Exchequer had been given the wrong legal advice. He was the secondary decision maker, the primary decision maker was the Chief Secretary to the Treasury, but the Chancellor was then subsequently given wrong advice. That was identified very shortly before the hearing of the first substantive judicial review. And so the question went back to the Chancellor, had you been given the right advice, would you have come to the right conclusion? And he said yes, and that was the basis on which the matter proceeded. It raised two quite interesting questions in this context. The first was whether it was necessary to get a witness statement from the Chancellor of the Exchequer as to the state of his mind, a question that also arose in Miller to some extent. The court said no. Secondly, whether the Chancellor should have been asked, what's your view now in the light of what we now know and the circumstances as they have changed, or what would you have decided then had you been given the right advice then? And the court said that the correct approach was the one taken by the Treasury, and that second approach should be taken by reference to the facts as they were. So I think that provides in some ways a rare blueprint for what to do if you're a public authority and you identify in the course of a JR that there have been mistakes. I think my time's up, so I'm going to hand back to Paul.
Fascinating, Tim. Thank you so much. Well, our last speaker is another of our fantastic junior public law practitioners, Emma Mockford. Jenny acted with Jenny in the Evil case that Jenny spoke about, and she and I are working on a really interesting case for the Public Law Project at the moment. Emma's going to talk about one of the claims for judicial review brought in relation to the Heathrow third runway, and many of you will remember judgment being given by the Court of Appeal in February of last year. So I'll hand over to Emma. Thanks, Emma.
Thank you, Paul. So I'm going to speak about a particular aspect of the Heathrow judicial review claims, which were brought in late 2018, and judgment was handed down by the Divisional Court in May 2019, followed by the Court of Appeal in February this year. The aspect of the judgments that I want to talk about is the court's treatment of issues relating to Article 9 of the Bill of Rights and parliamentary privilege. I'm sure some of you will be very familiar with Article 9 of the Bill of Rights, but for those who need a refresher, it relevantly provides that freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court. The privilege which is afforded to proceedings in Parliament by virtue of Article 9 is, the courts have repeatedly said, one manifestation of the fundamental constitutional principle of the separation of powers. It operates to prevent any challenge being made in a court of law to what is said or done within the walls of Parliament. And in doing so, it protects freedom of speech within Parliament. To give an example, it's well established, and this is the 1995 Privy Council case of Prebble, that a litigant cannot come to court and say that a minister or MP misled Parliament or acted improperly by introducing legislation. Article 9 prevents that. But of course, there are circumstances in which it is permissible to make a reference to parliamentary proceedings in court. An obvious example, which everyone will be familiar with, is that of Pepper and Hart. The courts may have regard to a clear ministerial statement as an aid to construction of ambiguous legislation. A more contentious question is whether there is an exception for the use of ministerial statements in judicial review proceedings, and if so, what the scope of that exception is. And that's the question which arose in Heathrow. More particularly, the question of principle in Heathrow was this: what happens when a decision maker has a number of good and lawful reasons for the adoption of a contested decision, but also one unlawful or potentially unlawful reason, which he gives only ever to Parliament? Can a claimant in judicial review proceedings rely upon that reason given to Parliament to impugn the decision, or is the decision maker entitled to rely upon Article 9 of the Bill of Rights to say that the statement made to Parliament is inadmissible? This issue was previously considered by the Privy Council in the 2007 case of Toussaint and the Attorney General of St Vincent and the Grenadines. And in Toussaint, what had happened is that the government decided to compulsorily purchase some land from the claimant. They gave a public explanation for that decision, which was that the land was needed for a learning resource centre. But in Parliament on the same day, the Prime Minister made a statement explaining that the reason for the expropriation was in fact the claimant's relationship with the previous government. The claimant sought to rely on that statement, unsurprisingly, in subsequent judicial review proceedings. And the courts below held that he couldn't do so because the statement was protected by Article 9 and inadmissible. That decision was overturned by the Privy Council in Toussaint. And the basic logic of the Privy Council's decision was that the claimant should be free to deploy in his judicial review proceedings any evidence available to him as to whether the public explanation given by the government for the expropriation of his land was a sham. The Prime Minister's statement to the House was said to be potentially relevant to Mr. Toussaint's claim as an admission or explanation of the executive's action, and he could rely on it for that purpose. So one might think that that gives a fairly solid basis for making the submission, as my client did in Heathrow, that there is an exception for judicial review where the purpose of your reliance on a parliamentary statement is to explain why the decision maker acted as he did. But the course of litigation never runs smooth, we all know, and opposition to that proposition came from a number of quarters. In particular, both the Secretary of State and Heathrow opposed my client's reliance on parliamentary material, and the Speaker of the House of Commons also intervened before both the Divisional Court and the Court of Appeal in Heathrow to say that Toussaint was wrongly decided and that the court should decline to follow it, it being a Privy Council decision only and not a decision of the Supreme Court. There's a spoiler alert I ought to give at this stage, which is that despite being invited to determine the point by us, by the defendant and by the Speaker, neither the Divisional Court nor the Court of Appeal actually did so. They said on the facts that the Toussaint question didn't require definitive resolution, but they did offer some very interesting and conflicting obiter observations on the issue nonetheless. So how did the arguments develop? Well, the Speaker made two principal points in support of his submission that Toussaint was wrongly decided. First, he said that the meaning of words used in Parliament cannot be a matter for the courts to determine, because in doing so, the court would risk questioning proceedings in Parliament, and that's what's prohibited by Article 9. So if a claimant says, I'm relying on this ministerial statement, which means X, and the defendant, minister, says, well, you're wrong to rely on it for that purpose, because although what I said looks like X, it actually meant Y, then for the court to determine that dispute, was it X or was it Y that was said in Parliament, it runs the risk of contravening the prohibition on questioning parliamentary proceedings. Second, the Speaker said that the position taken by the Privy Council in Toussaint was wrong because it had the potential to result in substantial unfairness to a defendant minister. The unfairness arises if a defendant is constrained in his ability to say to the court, when I said X, I meant Y. The possibility for that unfairness was said to be particularly acute in Heathrow because the Secretary of State for Transport made clear that if the parliamentary statements on which the claimant sought to rely were admissible, he would wish to say he misspoke when he made them. So how did the courts react to those arguments? Well, the Divisional Court, for its part, was unimpressed by the Speaker's intervention. Well, they accepted that the limits of the exception set out in Toussaint had not yet fully been tested. They said they had real reservations about the Speaker's submissions and inclined to the view that the key issue for the court is to identify the purpose for which a statement in Parliament is being relied upon. If that purpose is to explain the motivation for executive action that is taken outside Parliament, then that is within the exception laid out by the Privy Council in Toussaint. The Court of Appeal, however, inclined the other way. They were particularly concerned by the first point made by the Speaker, that by determining the meaning of words used, the court could, even at that level, be seen as questioning parliamentary proceedings. So the Court of Appeal described it as a fundamental difficulty, this issue around interpretation of words meant, and said that what could happen is that the court could end up trespassing on forbidden territory. And they also appeared to have some sympathy with the unfairness argument. So for all those reasons, they concluded, contrary to the Divisional Court, that there was substantial force in the arguments advanced by the Speaker. The question is, where does that leave us now? Well, it seems to me that the consequence is that what previously resembled an exception of some pedigree to the privilege, in the case of judicial review proceedings, where a claimant sought to rely on what was said to Parliament to explain executive action, is now in something of a quagmire. Undoubtedly, the decision of the Court of Appeal in Heathrow is going to make the position for claimants who are seeking to rely on the Toussaint exception more difficult, at least at first instance, unless and until the point is resolved by the Supreme Court. For defendants to judicial review proceedings, it may make an Article 9 argument more attractive. The other practical point is that the Speaker has very much pinned his colours to the mast on this issue. In Heathrow, he takes the view, and can be expected to take it in other cases in which this issue arises, that if there is any dispute between the parties as to what is meant by the words used in Parliament, then they must be regarded as inadmissible because the court cannot resolve that dispute consistently with Article 9 and the separation of powers. I think that's all we've got time for on that point, so I'll hand back over to Paul at this stage for questions.
Yes, well, thank you, Emma. In fact, thank you to all of our speakers, all of whom have kept very much to their timing, which I'm very grateful for. You won't have seen this, ladies and gentlemen, but we've been furiously WhatsApping each other, and I've been WhatsApping messages to our speakers when they only have a minute or two left to go. But they've done a great job in this novel context. Now, I gave you all my email at the beginning of the lecture, and we've still got until 1:15 for any questions. And so if any of you would like to send a question for me to put to any of our panelists, which I think is the simplest way to do it, I'll just give you my email address again. It's paul.bowen@brickcourt.co.uk. I do have some questions which I'm going to put to our panel. And I'm going to start off with one for Malcolm. Malcolm, are you there? Can you hear me?
Yes. Hi. Hello.
Malcolm, this question of amenability to judicial review, which is one that flares up pretty regularly, and it struck me that in the context in which you were describing KPMG's role, effectively discharging the function of the bank, it seems odd that they weren't found to be exercising public functions. But my question is this: we've also seen in recent years a development of the courts injecting into private law relationships, in particular contractual relationships, public law principles. So we saw it in the Cavendish Holding case, for example, where the court looked at the question of whether a penalty payment for a parking fine was a reasonable one, applying a Wensbury test. Does that development in private law mean that the question of immutability has become less of a black and white one, that an individual can get public law justice, if you like, even if they can't go through the public law courts by going through a private law cause of action?
It's an interesting question, Paul. I think the short answer is that wouldn't have helped Holmcroft, because judicial review was the only game in town. And that was because there just wasn't a possible private law claim. I mean, there wasn't a private law claim against KPMG because there was no contract between Holmcroft and KPMG, and the Court of Appeal was very clear about that. There was no possible private law claim against Barclays because it was time-barred, even if they could have afforded to bring one. And that was one of the reasons why the FCA set up the redress scheme in the first place. It said that basically private law rights weren't enough because they're too expensive, they'd take too long, and lots of them were out of time. And it had also been made clear in another Court of Appeal decision in which I appeared, called Elite and Deculus, that there was no contractual or tortious obligations between the bank and the client as to the conduct of the review process. So really, there's no if it wasn't amenable to judicial review, there was no cause of action. And the Court of Appeal, actually in Holmcroft, fessed up to that and said that, yeah, their conclusion exposed a gap in judicial protection. Which is interesting because in the Datafin case, that was why Lord Donaldson expanded the law of amenability in the first place, because he was concerned that if the panel on takeovers and mergers, which was a private law body that was governed by a contract between all of the members, wasn't amenable to judicial review, then what he called that remarkable body would be above the law. And, you know, Holmcroft perhaps not quite as remarkable as the takeovers panel, but the policy you would think would be the same. If there is a wrong, there should be a remedy. But the Court of Appeal, while taking that on the chin, realising that was going to be the consequence, wasn't moved by it.
Thanks, Malcolm. We saw Emma and Emily in both your cases that you talked about. The operation of Article 9 of the Bill of Rights. In Emily's context, the question whether investigating the policy and objects of the statute may in some circumstances butt up against the prohibition in Article 9. And Emma, also in your case, it arose directly. Now, in my experience of Article 9 is that it's used by the government when it suits them, and it's used, that's to say, if they don't want something being explored that's said in Parliament. But if they do, then they're perfectly happy to have it put before the courts. Was that your experience in either of your cases?
Perhaps if I take that one first of all, obviously I was acting for the government, so be a bit careful what I say. I mean, Article 9 of the Bill of Rights itself wasn't, so far as I remember, actually raised in my case, because it's relatively well established that you can look at parliamentary material to some extent when you're construing statutes. So I think really the key question in my case is how that interacts with the clear direction that what ultimately guides construction are the words used. And a point that we made in particular was that we accepted that there is sometimes what's sometimes called the mischief rule, where you can look at material to try and identify what mischief Parliament was trying to remedy. But we said that there is case law suggesting you can't look at Hansard statements when you're identifying the policy and object of the statute, and we said the mischief rule doesn't displace that clear direction in Spark Home, which is a House of Lords case. So I think the real critical question is when you're looking at the language used, and at the same time you're confronted with perhaps a report that was placed before Parliament that might shed light on that language. To what extent can the report determine your interpretation? And the line we were taking, which I think is right, is you have to be very careful, because Parliament may well have had in mind a particular mischief, but it doesn't necessarily only have one mischief in mind. So a report may raise a particular issue at a given time, but the draftsman, when it comes to it, may choose to address one or mischief plus some other mischiefs at the same time. So ultimately, everything has to be guided by the language. But of course, when the language itself isn't particularly determinative, that leaves you in quite a difficult position.
It is a curious feature, though, isn't it? Because we find cases. I think one of the cases that was brought in Strasbourg, which where the European Court of Human Rights looked at parliamentary material without any concerns about whether that gave rise to a breach of Article 9 of the Bill of Rights. And you can see how the European Court of Justice would have exactly the same approach, whereas our domestic courts see themselves as much more closely bound by those obligations. Is that something that you would agree with, Emma, from your experience?
I think that's very true, Paul. And I think the point you were raising about selectivity in terms of the government's position came out quite acutely in the Heathrow case, because there, as I said, the argument made by the Speaker of the House of Commons was that as soon as you have a dispute about the meaning of the words used in Parliament, that renders that statement to Parliament inadmissible in the context of any subsequent judicial review. And of course, what that gives rise to, the claimant says that gives rise to, is the possibility for artificial dispute. So as soon as the government wants to assert a privilege over a particular statement, it can say, well, I dispute the meaning of the words used, and therefore this material is rendered inadmissible. And that's, I think, a particularly invidious consequence, actually, of the position taken by the Speaker. And of course, the further point is that because the Speaker is also the person taking that position, in addition to the defendant, Secretary of State, the scope for them to intervene in any proceeding where parliamentary privilege is raised is obviously very wide. And they are on notice of cases where the point is afoot through government channels, as I understand it. So I think it's a point which arises from the government's perspective and separately from Parliament's perspective.
Well, thank you both. The other question that I wanted to ask, and this is really for Jenny and Emily, in relation to fact finding in the administrative court. There is, it's fair to say, a different approach taken in other jurisdictions around fact finding. What in other jurisdictions are called legislative facts. Those are the facts that relate to the underlying policy of a piece of legislation, for example, which we haven't yet adopted in this jurisdiction. And Jenny and I were involved in a case last year on behalf of a gentleman called Phil Newby, in which we were looking at the question of assisted suicide, where the government were seeking to defend the compatibility of the Suicide Act, the prohibition on assisted suicide, with Article of the European Convention on Human Rights. And they have produced evidence on which they relied for the underlying policy, if you like, for the legislation, which we sought to challenge. And we were unsuccessful, essentially, because the Administrative Court does not have the architecture, really, for resolving these issues. I mean, Jenny, it sounds like your case raised this in particularly acute form, and we've seen cases, haven't we, over the last few years where the courts have grappled with this issue. There's a distinction drawn from rights cases, and I know in the Al-Swedi case, where the court accepted that there may be circumstances where the presumption that the evidence put forward by the decision maker would be accepted on its face will be displaced. Was that something that you could have relied on in the Evil case?
So I think the type of legislative facts that you've mentioned, Paul, often arise in relation to policy questions and quite sensitive evaluative exercises. What I would say about the Evil case is that the position is even stronger because one isn't dealing with evaluative policy questions, which are a matter properly for government in many instances, but actually one is dealing with quite straightforward questions of what happened. And those are questions which, it seems to me, the court is much better equipped to deal with than the more difficult, nuanced questions of policy. In particular, in this case, I think, as I was saying, it's even stronger again because one is looking at the threshold question of whether or not there is a judicially reviewable act at all, which is obviously not something that one often sees, and that's why I think the Divisional Court described it as unique. If I were to draw a parallel with anything, I might draw a parallel to the doctrine of precedential or jurisdictional fact, where obviously the courts draw a distinction between an evaluative question, which is a matter for the public body, and a prior question of assessment, which remains a matter properly for the courts. And what I would say about our facts and our case is that they fit much more neatly into that category of really quite hard-edged questions that it's not only easy as a matter of practice, but also principled for the courts to be considering.
Yes, I can see how precedent fact, which is usually a question of whether the circumstances exist in which a public body can or should exercise its powers, should apply to the administrative court itself, because effectively it's a fact that turns on whether the administrative court can exercise its powers.
Yes, and that's certainly what we've tried to emphasise to the Court of Appeal in our appeal on this issue.
Well, we'll look forward to seeing the outcome of that. Thank you, Jenny. All of these questions around fact-finding are also linked to the court's approach to disclosure. So one of the reasons why the court tends not to order disclosure in the ordinary course of events in judicial review proceedings is not only because public bodies are under a duty of candour to engage with cards face up, as the term is used in judicial review proceedings, but also because the courts generally don't consider themselves as being suitable, the administrative court in judicial review proceedings, they don't consider it suitable for fact-finding, and that's one of the reasons often given why disclosure should not be ordered of the underlying facts relating to the decision under challenge. But I think that's something that's changing. I'm just going to ask Tim a little bit about his experience of how the courts are dealing with those candour and disclosure issues. Tim.
I think it's a fairly simple observation in some ways, but I think disclosure and access to documents is a growing issue in judicial review. Certainly in the last year or two, it's arisen in a good proportion of the cases that I'm instructed in, both for the government and for claimants. And my observation is that there's an increasing appetite on the claimant's side to see more documents. And also that the judiciary is relatively sympathetic to that. And I've been involved in a number of arm wrestles where I'm acting for the claimant, where there have been arguments about whether the duty of candour is engaged at the pre-action stage, which it is, to what extent, whether there's a kind of proportionality sliding scale and the extent of what should be disclosed changes over time. I think that's a really complicated question. I think the current case law on that is not as clear as it should be, though my very clear view is that, yes, the duty of candour is engaged early, before action, but that there is a proportionality element to this in terms of the kinds of searches and the kinds of redaction and so on and so forth that should be done. But as I say, I think this is a point that's arising more and more. I've seen more and more applications for specific disclosure. It arose in a slightly peculiar way, actually, in the BT case that I was talking about earlier, because documents were disclosed, ministerial submissions were disclosed early on, redacted, before counsel was instructed. And in fact, it was only identified right before the hearing that the legal advice to the Chancellor had been wrong, because the unredacted versions of the documents were reviewed again before trial. So I certainly, it's been my experience, it'd be interesting to hear what others think as well, that disclosure is becoming much more frequently a part of the landscape. And my impression as well is that the judiciary is sympathetic, and there are some concerns that not enough material is coming out, actually, in a judicial review context.
Thanks, Tim. Well, we're coming close to the end of our session, and it would be odd, I think, to have a public law seminar of an hour and a quarter without anybody mentioning the current crisis and the public law issues that are likely to arise from the COVID-19 pandemic. And I have had one question, in fact, from one of the delegates asking us to talk about the public law duties in relation to COVID. Those are obviously enormous. And so what I'm going to do, just by way of conclusion, is to pick up a couple of the issues which I think are likely to find themselves being litigated. And if any of my colleagues want to jump in and add to these, then they're very welcome to. I know there's been a very recent paper written by Tom Hickman, who has looked at the COVID regulations, which in fact are not issued under the Coronavirus Act, but under other public health legislation, with a view to highlighting that the lockdown provisions, in fact, are not authorised. They're ultra vires, and it will be interesting to see whether any of the convictions that have arisen from people being issued fines for failing to comply with the lockdown restrictions will be challenged by way of judicial review or by way of a challenge through the criminal courts. I think we're going to see lots of challenges arising out of the financial bailout from companies that are either told that they don't qualify, or that the scheme isn't generous enough. That might involve, for example, some organisations, associations of self-employed bodies, because of course self-employed people are excluded above a certain income level from any furlough payments, which if they were employed they would be entitled to receive. I think we're likely, this is an issue that I'm in fact writing a blog about, which is going up next week. We're likely to see a lot of challenges coming out of the responsibilities the state owes under Article 2 to investigate the government's response to the pandemic, in particular issues around its efforts to procure personal protective equipment for NHS staff, for example. And I can see those sort of challenges, public inquiries and calls for public inquiries being among those that we're going to see litigated over the next month. So I don't know if anybody wants to add to that list of coronavirus hot topics.
One point on the surveillance side, which is potentially quite interesting, is the use of communications data to trace and deal with possibly infected people. The reason it's quite interesting is that, at least to this point, the IPT has suggested that when data is used in a new way like that, the government has to make a public statement, a clear statement that it is doing so, that it's using powers for that purpose in order for that kind of data retention and access to be lawful. Thus far, I'm not aware of any such statement, so it'd be quite interesting to see if anything happens in that space, both by way of statement and or by way of challenge.
I don't know if any of my other colleagues are going to volunteer or keep their counsel. I think, though, we are now 1 minute from the end of our advertised finishing time. So I think what I'll do is just round up by asking you all remotely in the privacy of your own homes to give a round of applause to each of our excellent speakers. We've all provided much food for thought. Please do, if any of you have any questions arising out of anything that you've heard, send in questions to us via email. We're always very happy to field those sort of questions. And indeed, anything else that you want to discuss on the public law front. And I think it only remains for me to thank you all for attending today, and your patience as we've made our way through the technological challenges, and I hope you'll join us for what will inevitably be the next one of these, I hope before too long. Thank you very much indeed.